Good morning. Happy Thursday. There was a video that I was asked about. Maddie, apparently, she used to be known as Constitutional Corner. Now I think she's like Mad Maddie or something along those lines. And yes, I know she is biologically male. No, I don't care. I am going to use her pronouns because that's what Maddie prefers, and I don't care. It doesn't matter to me whether or not she wants to identify as a her. It doesn't matter. I don't know why it matters to everybody else, but it doesn't matter to me. I don't care. Anyway. So, apparently, my understanding, having watched a couple of her brambly kind of videos, like I have any room to talk, she was charged with some sort of a traffic offense or a parking violation of some sort. And while preparing her defense for this traffic offense or parking violation, she called the county clerk or a clerk at the county court or something along those lines and recorded the conversation without notifying the clerk that she was recording the conversation. She published that conversation. The county district attorney of whatever stripe they call them in Florida found out about it and brought charges for some sort of interference with communications sort of statute. Florida has it's an all-party consent state. I know a lot of people like to call it a two-party consent state. You're assuming that a conversation only has two people in it. It's an all-party consent state. All of the parties to the conversation have to agree to have the conversation recorded in order for the recording to be lawful. As opposed to a single-party consent state where only one person to the conversation, no matter how many people are talking, if one person wants to record it, they can record it. That's a single-party consent state. So, again, my understanding is she went to court on the traffic or parking crime. It must be a traffic crime. Something about her car being her motorcycle not blocking the road and a vehicle being able to go around it. I'm not entirely sure, and I don't really care enough to find out all the details on it. But she appeared for her trial. I believe she was represented by counsel Eric Friday or something. Maybe it was a different hearing that she was represented by Eric Friday in. But she won. She won the particular case, the traffic violation. She won. So congratulations. And I think she then assumed that they would drop the charges for the wiretapping or eavesdropping or whatever they call the statute, where she recorded the conversation with her and the clerk. And that doesn't. The two aren't connected, and she was saying that the county judge violated her rights under Terry v. Ohio, and I want to remind you what Terry v. Ohio was. Terry v. Ohio said that in order to detain someone, you had to have reasonable suspicion that they're about to commit a crime. They're committing a crime. They're about to commit a crime. They've just committed a crime. And reasonable suspicion is, of course, articulable facts and the reasonable inferences you can draw from those articulable facts. I know a lot of people like to call it reasonable articulable suspicion. That's only in a few circuits that they use reasonable articulable. It's the reasonable suspicion standard. Terry v. Ohio also stood for the proposition that you could perform a Terry frisk, which is a pat down for weapons, if you have a reasonable suspicion that a person is armed in the process of committing a crime. In the case of Terry v. Ohio, of course, Officer McFadden saw Terry and some other people looking into windows suspiciously and conversing among themselves. From those articulable facts, he drew the reasonable suspicion, the reasonable inference that they were about to commit an armed robbery, a stick-up job. And that is, if you're going to do an armed robbery, of course, you're going to be armed. And so he patted them down, found a firearm, and it was the firearm that Terry was convicted of, firearm violation. So what does that have to do with Maddie and her recording the conversation? Nothing. It has nothing to do with it. Where a lot of people, let's make a simpler hypothesis, shall we? A simpler scenario. Let's pretend that an officer believes that your taillight is out. It appears that your taillight is out, and assuming the statute requires you to have a functioning taillight, then he pulls you over. Once he pulls you over, then he looks in the window and sees that there's, cocaine on the seat of the car. And so then he arrests you for the taillight and the cocaine. Reasonable suspicion allowed him to make the stop, and that's a very low standard of proof. Again, it's just basically, can you say facts that a reasonable officer could draw rational inferences from to say, you could be committing a crime. It's a very, very low standard of proof. Provided you have two brain cells in your head, you could probably come up with enough facts to give a court to establish reasonable suspicion. It is a ridiculously low level of proof. Ridiculously low. The officer has to be a real fuck up in order to not be able to establish reasonable suspicion. I mean, it's absurdly easy to do. Because you got to remember, Officer McFadden saw guys walking up, looking into windows, walking back and talking to each other. They just did it too many times. I mean, stupid. Illinois View Wardlow, guy standing at the corner of a building with a sack in his hand, sees the police and runs. Obviously must be committing a crime, right? I mean, it's absurd. Anyway, the point is that justifies the stop. That's all it does. That's all you need for the stop. Anything then that flows from that stop is fine, as far as he looked in the window, he could see the cocaine, it's fine. Now, in order to be arrested for something, you need a higher level of proof. Technically, you need probable cause, which means that it's somewhat nebulous. It's not a preponderance of the evidence, but it's you probably did it. There's a good probability. It's not a possibility, it's a probability. Like, who knows where that probability is? I mean, it's up to the court, but there probably was a crime and you probably committed it. It's not a 50% possibility, but it's greater than a possibility, but it's not necessarily 50.5% or greater. It's a very nebulous term, but it's bigger than reasonable suspicion. It's a little harder to prove. That's typically it. The judge will typically establish that maybe it goes to a grand jury, but somebody somewhere before you actually before you can actually go to trial for the crime, there will be some sort of a procedure in place, may vary state to state, etc., that some finder of fact will determine whether or not the officer had probable cause for the arrest. And indeed, the prosecuting attorney, AUSA or DA or whoever it is, has a duty to not prosecute cases if there's not probable cause. So that's a higher standard of proof than the reasonable suspicion that justified the initial stop. Okay, so it's just because if you can't prove reasonable suspicion, it doesn't mean there wasn't probable cause. That's where I'm going with that. And then the third real level of proof, I mean, there's clear and convincing also in there, but the big of the big three, the third one is the beyond a reasonable doubt, which isn't really beyond a reasonable doubt. It just means that you're I mean, beyond a reasonable doubt is as a really high standard, and I don't think that juries ever really apply it. But it's typically what they will do is they will be generally speaking certain that not only there was a crime, but that you committed it. And they're not always right. But that's a very high standard of proof. And just because a jury doesn't find you guilty, or a court doesn't find you guilty beyond a reasonable doubt, doesn't mean that there wasn't probable cause. And whether or not there was probable cause doesn't mean there wasn't reasonable suspicion. So if you get, like, going back to our hypothetical where the officer thought that the taillight was out, and then he saw that there's cocaine on the seat when he walked up to give you a ticket. If you win on the taillight charge, whatever that would be, that doesn't invalidate the stop. It doesn't invalidate the stop because the prosecution failed to establish beyond a reasonable doubt that the taillight was out, does not mean that there was not reasonable suspicion that the taillight was out. So I don't know why Maddie was invoking Terry v. Ohio. The other case that Maddie raised that she thought was her right was being violated under was Brown v. Texas. And Brown v. Texas is a pretty old case. There was a previous version of the Texas requirements to identify to the police, wherein all the officer had to do was lawfully stop you and demand your ID. And if you did not provide your ID at that point, then the officer could arrest you for failure to ID. Now, that Brown v. Texas was like 1980 or thereabouts, 79, 81, somewhere right around. Because I remember saying it was 40 years ago, so somewhere right around 1980. Although I'm going to say 79. I'm going to say it's 79. I don't know why I'm stuck on that point. Anyway, what the Supreme Court held was that you can't just have random papers, please. There has to be some underlying component to it. There has to be at least reasonable suspicion or more to justify a crime of failing to ID. And then, of course, Hibble versus the 6th District of whatever. Hibble came along afterwards, and the court confirmed that as long as the statute requires at least reasonable suspicion, then they can demand ID, and they can make it a crime to fail to ID. But there has to be that reasonable suspicion component. And as far as I'm aware, nothing that Maddie was charged with, I don't believe there is a stop and ID in Florida where the cops don't need at least reasonable suspicion. I'm not even sure if there is a stop and ID, but I don't believe it would be something that would fail to require at least reasonable suspicion. And I don't think that Maddie was charged with anything about failing to ID. So I'm not entirely sure where she was going with that. Throwing out random Supreme Court case names isn't impressive, especially if you don't understand the context of them. So I hope that people can now understand a little bit the context of those case names she was throwing out and why they don't apply to what she's doing. Now, the other thing that I want to talk about was she's hiring an attorney. So if you want to support her, honestly, I don't have any issue with her trying to fight this particular statute and try to make an exception, to carve out an exception, a constitutional exception for recording telephonic communications or recording communications between government officials, yourself and government officials. I don't have a problem with that, and I just want to point out that she's trying to hire an attorney. He does appear to be a qualified attorney. He's a big Second Amendment attorney, so she needs to raise money. So if you go to her website, Maddie, or not website, her YouTube channel, Maddie. She's going to be doing some sort of a fundraising thing on Sunday. So if you want to support her, I don't have a problem with it. And honestly, but anyway, I just want to point out that she is up against it on this, because there is no authority, there is no case she could cite that would suggest that a law like that would be unconstitutional, that it would violate some constitutional principle to prevent people from unilaterally recording conversations with government officials. It doesn't. You can't point to something in the Constitution that says I automatically get to do this. And I know people are going to point to, Glick and Fordyce, et cetera, but all of those have a few things in common. The officers were in public. They were in the performance of their public duty in public spaces. There's no real expectation on the officer's part that anything that they're doing isn't going to be overheard by other people or captured or et cetera. And in public spaces, you have more rights than you do with phones. Like, for example, if I'm standing on a street corner, I could yell, at passersby, theoretically speaking, as long as I don't, cause a public disturbance. But I could be like, hey you, 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 and try to get someone's attention over and over and over and over again. I mean, if they're sitting on a park bench nearby or something, there's no problem with that. But if you call someone over and over and over again, because you're invading their privacy, because they're not placing themselves out in the public, they may be at home. They have more expectation of privacy there. The court's going to look at that, and the court isn't, in my opinion, that you're going to be hard pressed. Number one, because you don't have any authority to support your position, so you're going to have to be making a novel argument. And there are always going to be instances where the court's going to say, well, technically the court is a government official. The judge is a government official, and let's say the judge has a Zoom hearing with a parent or something about a child in a dependency action or something along those lines, which at least in California, I mean, you don't say jack crap about a dependency action. You don't say the name, you don't say the case number. You don't talk about dependency actions, because these are kids that are in desperate situations, etc. Which is why I'd be really surprised if Al got, or not Al, what the fuck is it? Earl. If Earl got any of the child welfare, I don't know what they call it in Texas, but he was seeking the child welfare records for his daughter that he's accused of raping. I would be absolutely amazed if those come out in open court. Just absolutely amazed. But I mean, technically, I guess it could happen. But anyway, my point is, if a judge is talking to a parent in a dependency action, and the parent then records that conversation, I mean, I guess there are technically court orders in place, but if you carve out this constitutional exception, then even a court order would have to meet whatever constitutional standards. And I just don't see it happening. Governments can't engage in private negotiations with contractors over things. A government employee can't, do confidential informant thing. I mean, there's just all sorts of issues with it. So all I'm saying is that it's going to be a long road to hoe. It's going to be a tough hill to climb. But if you want to support Maddie on it, I mean, if you think that you should be able to record any government official at any time in any conversation that you're having with them, whether or not they're where you're recording, and whether or not, they're in a place where they have an expectation of privacy, then this is a good case for you. Throw your money at her. Let's because in order for her to really bring any civil action, she's going to have to win on the criminal action. So I guess she technically doesn't have to win on the criminal action, but if she wants to succeed on the civil action, she's going to have to win on the criminal action. So anyway, there you go. So thanks for watching. I hope this was informative. Have a wonderful day.